Hello, fellow advocates. My name is Anton Gershler. It's my privilege to be the guest host on this episode of Trial Alchemy. Today's special guest on the podcast is the chief alchemist himself, Mr. Monty McIntyre. Monty is the past president of the San Diego chapter of the American Board of Trial Advocates, known as ABOTA for short. And ABOTA is an invitation-only organization. We're comprised of both plaintiff and trial defense attorneys as well. We are committed to keeping civility in the civil jury practice, protecting the right to civil jury trials, and protecting an independent judiciary. Monty has a wealth of firsthand civil trial experience in business employment, insurance bad faith, real property, and every type of tort litigation imaginable. These days, Monty is affiliated with ADR Services, and his intelligence and calm persistence elevate his private mediation, arbitration, and referee practice to the very top tier. And I know this from personal experience to be true. Monty also provides attorney mentoring services to law firms, and he's the publisher of California Case Summaries. And if you're one of the few people that doesn't know what California Case Summaries are, it's an online subscription service providing a one-paragraph summary of every published California appellate opinion, and it's organized by practice area. Each summary is a 2-minute read, and it's a must-have for every busy civil litigation practice. If you don't have it, get it. And of course, Monty is the creator and regular host of this podcast, asking experienced ABOTA attorneys and judges to reveal their secrets for success in the jury trial arena. Monty, welcome to your show.
Anton, thanks for being the host and the interviewer today. It's a different experience for me.
As it's your time to shine, my friend. Let me ask you a few questions about first of all, how did you get into the law?
I decided early on, probably unusual, I was only a seventh grader. It was 1967, and we had been going in the country through a lot of civil rights activity for several years. And of course, the Civil Rights Act had been passed a few years before. And what I observed as a young person was that there were a lot of lawyers that were involved in that process. Not only people involved with the protests, but also people involved with writing legislation and getting things passed. And I really decided in the seventh grade, I thought that I could try to help people and help make things better by becoming a lawyer. And I thought then that would mean becoming a lawyer and then ultimately getting into trying to be a legislator or things like that. Now that happened to change over time, but I kept with it and got all the way through college and law school, even though nobody in my family had ever been a lawyer. And I'm glad I stuck with it because I do have a passion for the law, and I still have that today.
When you were thinking about going into the law, where did you imagine yourself? Where did you pre-imagine or pre-visualize yourself being in the law, or did you have a clear vision at the start?
When I was a seventh grader, no, I didn't have a clear vision. I think by the time I was older, but not yet in law school, I was probably still thinking I wanted to get into government somehow. But by the time I got into law school, I got involved with doing the moot court competitions, and I loved being an advocate and making those arguments. And that's when I decided I wanted to try to become a trial lawyer. And then I was lucky enough that in my second year of practice, I got a job at a law firm that was in one of the best, maybe the best or one of the best insurance defense firms in San Diego called McGinnis, Fitzgerald, Reese, Sharkey, and McIntyre. And I wasn't related to the named McIntyre, but everybody thought I was his son, so they treated me with undue respect when I was a kid who didn't know anything.
Didn't hurt, did it?
It didn't hurt a bit. I didn't tell him any different either. So, Anton, for you folks listening to the podcast, Anton used to be at another great insurance defense firm that was just several floors above the McGinnis firm. And that's how we met each other in the early 80s. And actually, it's another interesting thing, Anton and I were admitted into a BOTA, the same meeting in the same year in the San Diego chapter in September of 1995. Now, I figured since my name started with an M, Anton would have to go first, and those bums made me go first, and I learned what happened when you got admitted in our chapter. But we'll leave that secret for now.
Yes. Yes. Okay. And when was your first jury trial? How long were you a lawyer before you got your first verdict from a jury?
Well, I think I had left the McGinnis firm. I wanted to have my own practice, and I think it was about 86, so maybe 6 years in to practice. I had my first jury trial. Of course, you kind of get beat up in your first jury trial because you're
Mhm.
all learning and you don't know what you're doing at that point.
Yeah, luck has a place in the process, whether it's your first one or your most recent one.
Yeah.
The as in my old firm, which was originally Rhodes, Hollywood, and Neal, now Neal Diamond,
Yeah.
their motto was you don't have to be good, you just have to look good. I don't know if there was any truth to that, but I hear you. What was your most, you've had your share of victories, I'm sure, I know. And what was your most satisfying trial victory, if you can recall?
Well, I've had a lot of victories that I feel satisfied about, but I think about one of the earlier cases I tried, and maybe it's satisfying because it was early on, but it was an example of where we went through some hardship, but it made a difference. I was representing a plaintiff, and when I started my own practice, I was still doing some insurance defense work, but I was taking on more plaintiff's work. I took on this case for a paramedic who had been injured when he was working at a different location. This paramedic, they worked in teams of two, and normally they were assigned to the Rancho Bernardo fire station, and they worked with the fire department, which was a different group. But they got sent to a hospital located in downtown San Diego, and they had to do about a 3 day shift down there. So it was 24 hours a day. They were gone for 3 days. And this poor fella who loved being a paramedic, one night at about 2 a.m. after they came in from a call, and they had to go back down to the basement where where their beds were for them to sleep. And it turned out that the hospital had this hallway in the basement, and they had filled it up with used furniture they weren't using anymore, almost stacked all the way to the ceiling. And my poor client, while he was walking to go to get some sleep or early in the morning, he hit something and he ended up falling down and he had a shoulder injury that turned out to be pretty serious. The labrum in the shoulder, the cartilage was torn, and he had a permanent injury once they finally got around to imaging it, which took him a while. And he ended up having to get retrained. So this is a case where I thought there was a lot of responsibility. He was a great guy. He's still alive. And the poor guy, we go to a settlement conference, and this was like in December years ago in the late 80s, and we go see a judge and a plaintiff's lawyer and a defense lawyer. And I'm thinking, okay, maybe we can settle this case. I can get some money for my client, Bill. I go and talk to the judge, tell him what's going on. He sends me out. Defense lawyer goes in. Defense lawyer comes out. Now it's my turn to talk again. And the judge tells me in his chambers, he says, well, Mr. McIntyre, I think this case is a fake. I think your client set this up with his partner.
Oh.
And I don't think this is a real accident. And I think if you try this case, you could lose your license. Now, that's the
Whoa.
scariest hell thing to hear when you haven't even practiced law for 10 years. So I'm kind of a little bit in a daze. I walk out, keep my poker face, walk out to see my client, Bill, take him out of the courtroom, go into the hall, and I say, Bill, The judge thinks this is a fake, it's a setup. He thinks you and your partner faked this to get this money. I'm going to ask you one time, and I want your honest answer. Is this a fake or is this real? He didn't blink. He said, Monty, it's real. It's really happened. I was really hurt. And I said, okay, Bill, I believe you. Now, fortunately for me, even though I was a little bit scared, and anybody would be, by the time I was walking out of the chambers and starting to talk to Bill, I had already realized, look, if I believe Bill, I have to fight for him. And when he told me it was real, I said, okay, Bill, we're going to reject this piddly settlement offer they made. Now, the defense had offered a whopping $5,000. So they thought it was a crappy case and they're going to win. And the reason the judge thought the case was a setup was these guys, when they went down from RB in their normal firehouse and went to this hospital, they were going to be there for several days. His partner brought a camera and they took some pictures while they were tooling around, including they actually happened to have one picture they'd taken of the hallway earlier in the day, showing where they were going to the quarters. And then his partner, after Bill got hurt, took a picture of the hallway early that morning. So the judge was convinced, oh, this is a fake. So the judge tells me when I say we're not going to take the 5,000, we're going to go to trial. He says, well, Mr. McIntyre, you could lose that case. But I tell you what, I'm kind of interested. Let me know what happens after it's over. So we get sent to a very defense-oriented trial judge, and we tried this case, and it's, I don't know, a month later or something like that, and I get a plaintiff's verdict. Everything comes in well. Bill's a great witness. He's a very likable guy. And I get a verdict of something like 368,000. Back in the late 80s, that was like millions of dollars.
Yeah, adjusted for inflation, that's a big verdict.
I mean, that was a big verdict. It was the biggest trip and fall, or whatever you'd call it, verdict that I knew of at the time. And a little bit at the ending, we walked out and celebrated after we got the verdict, but I didn't call that settlement conference, Judge, until the next week. And I did call him up. And the day I called, I said to his clerk, well, I'm Mr. McIntyre, and we were here for a settlement conference last December. And he goes, oh, we already heard about it. The moment the verdict came in, the clerk of that court called us and told us what happened. So what was so great about that case was that made a big difference in Bill's life, because it gave him the funds ultimately to go on, get his new training, move on in life. And I enjoyed getting a fee, but I've long forgotten about that. But I will always be thankful that I was able to make a difference in his life. And that's one of the great things we get to do as trial lawyers. We get to fight for our clients, could be playing for defense, and we can make a big difference in their life. And that was a real rewarding moment to stand up for Bill, fight for him. And I was so happy that we got a good result.
Nice. That's wonderful. Let's jump into the time machine. Okay, Monty, that was in the 19, I was going to say the 1880s? No, the
Yeah.
1980s. And here we are in the 2020s, and times oh my, how things have changed. And we now have one of your most recent publications in your California case summaries was basically lawyer beware of artificial intelligence.
Right.
And using it as a research tool that's fraught with problems and hallucinations and false citations and things of that type. And I suppose, I hope over the passage of time that those problems will get ironed out. But you see and read of and hear of examples of this all the time. How do you see artificial intelligence or AI affecting trial practice going forward?
Well, in terms of the courtroom and trying cases of the courtroom, I'm not sure I've heard of things that are dramatic differences yet. I think what we've seen very quickly is a lot of use in doing discovery and working up the case and doing all the things you have to do to prepare for trial. And I think we'll see more of that. I think in terms of the future, the one thing that AI won't be able to do, and I think trial lawyers are safe because of this, is they're not going to replicate the trial lawyer. You have to have a human being in the courtroom, being an advocate, representing their client. And I don't think we'll get AI that will do that. But one of the things I could see happening is AI may become used more and more to, let's say, with younger generations coming in as jurors, to try to figure out and fashion how do you message the story of the case in a way that will communicate with them and their generation. Because I've heard from some folks, and I think it makes some sense, that some of the younger generations who we're starting to see in the courtroom, they really view the world in some very different ways than the way we may still view the world, and we're aging out at this point. So I think AI will have some impact. I hope it has more positive impact than negative, but it's still going to have both of those impacts. That's kind of some thoughts I've got at the moment about that.
Yeah, they grow up in a gaming culture. Maybe we have to put little tokens as a reward for the right verdict or something along those lines. It's presented as a video game.
Yeah.
I don't know. I hope you're right. I hope there isn't an AI replacement for the up and coming generation of trial attorneys. You know, you mentioned a minute ago, Monty, about your client Bill being a nice guy. How important would you view credibility then or now to be credibility and likability? How are those factors? How do those elements factor into trial success or failure?
Well, I think they're very important, especially in plaintiff side work. I know you've done both, plaintiff and defense, but I've done both in not only torts cases, but business and other cases. You know, your client, the more likable your client is, the better your case is going to be, no matter what the other issues are. And it can be a real detriment if your client is not likable. Credibility is, I think, the most important thing based upon my trying of cases. The most important thing is, does the jury believe that you as the trial lawyer has credibility, and does your client have credibility, and do your experts and witnesses have credibility? It's something where they're skeptical of everybody coming to the courtroom. And I think as a trial lawyer, you have to start building a connection and credibility with them from the beginning in your voir dire, in your mini openings, and all of that. And credibility and likability is hugely important. Now, I think a lot of lawyers kind of miss out some common sense likability things. For
Like
example,
what?
when you're sitting on the at the table, usually the only thing you've got at the table, other than your papers and pen and other stuff, if you got a laptop up there, is a little water thing and some cups. Just the common courtesy of asking your client if they want a cup of water during the trial and doing that consistently throughout the trial shows that you're somebody who's being concerned about your client. Being courteous to the bailiff and the clerk of the court and other staff personnel is very important, because the jury is watching everything. And if you're friendly to the judge, but you're a jerk to the other people, they're not going to like it and they're going to ignore it. I don't know if you remember the old courthouse. I'm sure you do, but you know, in the old courthouse in San Diego, you'd come in from the hall and there'd be a little half gate, and somebody would have to open that gate so they could get into the jury box. Well, the bailiff would usually hold open the door to the hall, and then I noticed in my first few trials, the jury started kind of struggling with, well, they're trying to go through and somebody should hold it open. Well, I just started standing next to this thing and holding it open. I wasn't looking them in the eye when they came by, but I was just helping them get in. And that's just being courteous. And I think they notice that kind of stuff.
Yeah, me too. I think jurors look for you to be professional, and that means not showboating or grandstanding, except when it's your time in the to give your argument. If that requires a little showmanship, fine, but not in your. I was always told, take care of the clerk, and everything else will be fine.
Well, that's true.
Let's talk a little bit about selecting that jury. When you pick a jury through the process of voir dire, um, again, based on your experience and what you know and learn of people's current experiences in trial practice, where do you think we have come to, and where do we still need to go in the use of jury questionnaires? Do you have any thoughts about that?
Let me do this, and thanks for talking about that. So before we jump into voir dire, I want to address a question that I asked all the guests, and I want to say my 2 bits on it. And that is, the question that I always ask is, what's the most important part of a jury trial and why? So let me answer that first, and then let's go to the voir dire.
Okay.
So I thought when I started this podcast that I would get different answers to that question, and that's proven to be true. Now, there's definitely a number one most common answer, and that is voir dire. We'll talk about that. And probably the second most common answer I've heard is opening statement. My answer to the question is, it depends. Now, I agree that in every case, the jury that you pick is vitally important, and that may make all the difference. But I have seen other examples where maybe that wasn't the thing that made the difference. I think opening statements can also be very important because of primacy, and you get the first chance to really tell your full story, and it may make their decision. And studies have shown that a lot of the jurors have already made up their mind by the time you get finished with opening statements. But why I say it depends is I've been in cases, and it could be on the plaintiff side or the defense side, where I've seen the case won or lost on cross-examination of a witness. If somebody takes down an expert witness in cross and they fall apart, and it can happen even though it's not very common for experts, a cross can make all the difference. And I've seen that happen on some occasions. And I've even seen final argument make a difference. And my example of that one is the case I tried for Bill, the paramedic. So here we had this case, and we're in the middle of trial. Now we had those pictures, the one that showed when they got there early on in the walkway and then after the fall. Heck, you know this, after over 2 years or so working on a case, I must have seen those pictures thousands of times, right? You look at them over and over and over and over. But there is something about being in the crucible of it's the night before, I'm getting my final argument finished up and prepared, and I'm looking at those pictures again and again and again. And you know what? I saw something I had never seen before.
What was that?
That night, before my closing argument, I realized on the earlier in the day picture, I saw some chair high up on the right side, about the same height as shoulder height. And I hadn't noticed this before, but that chair wasn't there in the post-accident picture. The same chair was not there. And what I realized was that's what he hit. all Bill had been able to say is, I hit something. I don't know what it was. It kind of hit me in the right shoulder. And now I'm sitting there that night going, holy crap, that's what he hit. So as you know, and I knew, I got to make two final arguments as the plaintiff the next day. But I also knew I better talk about what happened, the mechanics of the accident. He's walking down the hall, he hits something, he hits his right shoulder, because as we both know, if I didn't talk about that in the opening closing argument, and
Right.
I try to talk about that in the final closing argument, I could be cut off. So I made the decision, I'm not going to talk about what I observed in those pictures until my final closing, but I would talk about everything else in my opening closing. And the defense didn't see it coming, and we just kicked their ass. And the final argument made all the difference in that case.
Yeah, it reminds me of an experience I had in a federal jury trial early on, and on their rebuttal argument, it was a crash as to who caused the crash of a truck versus a pickup truck, and the comparative fault was really the only defense we had when I was on the defense side of that, and the stresses and strains of the they can look at the strap of the seatbelt and tell whether it's been stressed or not, and with the absence of any of the microscopic stress marks, they can infer from that that the seatbelt wasn't on because it wasn't tensed up on collision.
Mm.
And so I pretty well, with my expert testimony, established there was no seatbelt on. And that on their closing, the plaintiffs in that case very astutely took a 3x5 picture of the car, the truck, the victim, the plaintiff's pickup truck crushed, like a smashed like a tin can, and held it up in front of the jury because their argument had been on their closing that the seatbelt was inconsequential as far as the plaintiff was concerned. The semi would have went through the pickup truck anyway. But to make that point on closing, they just held up a picture of the crushed pickup truck and didn't say a word. And I was the one that didn't see that coming, and we got crushed. And my only pleasure in that case was keeping the punitive damages because our driver had been under the influence of alcohol at the time of this, which is a whole other story. When I get to tell my stories, that'll be one of them. But yeah, I hear what you're saying. So when you go back to what's most important in a particular case, it's kind of sounding to me like it depends on the case.
Yeah, I think it does. And it depends upon the case and depends upon what happens in that case. You don't know how it's going to play out exactly. And you know that from trying a lot of cases. So let's go back to the voir dire that you started with, and we'll continue
Yeah.
on that. And that is, I think voir dire is very important, but I want to share something that I tried as an experiment. Normally, in preparing for voir dire, you might be doing some focus groups or other things, but you might be writing out the questions you're going to think about for the voir dire. But before I started an experiment that I used in 3 trials, my last 3 Superior Court jury trials that I've done. And the experiment was this. I started learning in, I don't know, the early 2000s about this concept called intention. And when we think about things like quantum physics, what we know is that all matter, when you get down to the smallest particles, is just energy, and it's constantly in motion. Even though everything looks solid, or many things look solid, everything is still energy at the basis. So in that sense, there's an interconnectivity between everything. And so I was thinking before one of these trials, I thought, well, if that is true, maybe I can do something even before the trial and see if that has an impact on what happens in the trial. So I had this plaintiff's business dispute case with an oral contract going to trial. And what I did, this was the first time I experimented with this, but I kind of used the same process all three trials. 30 days before the trial, I started doing this intention every morning. Now, I've had a practice for many years of doing meditation in the morning and then doing a series of intentions. And so in the 30 days before that trial, I added this one intention that said, when our trial begins, we will be sent the perfect panel of 40 potential jurors, and we will pick the perfect 12 jurors and perfect one or two alternates for this case. And every day, that was the intention I had. So the whole thought there was, I want to get the perfect group sent to
Right.
our courtroom. And then the day we picked the jury, when the case started, and as you know, once we've picked the jury, you've got your box on your yellow pad with all the names, and you know their name and information for juror number 1 through 12 and the one or two alternates. And so each day of the trial after they were picked, early in the morning, I'm sitting there in my living room doing this intention, and I'll give you just this idea of what I would do. I would say, juror number 1, John Jones, I'm connected to you, you're connected to me. And then I would do other intentions saying that, I wanted him to be open and receptive to our evidence. And I was certainly also giving off the intention that I wanted them to ultimately vote in favor of my client when they got to their verdict. I did that for every one of those people individually and the one or two alternates. Did that all the way through trial. And I continued doing that even if they were deliberating. This jury didn't take a long time to deliberate. And once they returned their verdict, 12-0 verdict. And they give my client, he gave me every penny I asked for my client. We had a resounding 100% victory. Now, I had had verdicts of 9-3, 10-2, and 11-1, but I don't think I'd ever yet had a 12-0. And so I thought, wow, I like that. So the next case I went to trial on, I said, I'm going to do the same experiment. Now, this time I was on the defense side, and it was kind of a business contract fraud kind of a dispute. Went through the same process 30 days before and during the trial. 12-0 verdict, total defense verdict, plaintiff got nothing. So I go, I like this a lot. I'm going to keep doing this. So my next trial, same process, and business dispute. Again, I was on the defense side, similar kinds of issues. And once again, I got a 12-0 verdict. So it may all be just pure happenstance. It may be that my skills developed over the years and I got 3, unanimous verdicts because of those things. But I think there's something to it. And so I think from the connectivity of all of us energetically, I think there are things that we lawyers can do even before the trial starts to help our clients get the best possible result. And so that's one of the things that I started doing to get prepared for voir dire. And, you got to go try to connect with everybody when you're talking to them and try to get to know them a little bit as people the best you can with the little bit of time that you're given. But I think doing some of that pre-trial work, the 30 days ahead, can pay off. And so that's something I wanted to share because it's not something you commonly hear about.
I've never heard of that before.
Yeah, I think there's something to it. At least in my experience, there has been.
I think a lot of us do that, Monty, though, by without the intent per se, but the focus being a different word for the same process, saying like, what if I were the juror and who do I need to sit there with the same frame of mind that I think we think on our side might be necessary to receive our evidence favorably,
Yep.
or the opposite. And that's the whole voir dire process, right? Of pushing the extreme folks off the edge of one side or the other and hoping that you get something in the middle. But this really sounds like it takes it the next step, not just settle for an average, but settle for or reach out and connect energetically with people who, and I think by the time you get done doing that yourself, you're the one that's getting energized as much as your prospective jurors.
Well, yeah, I mean, I think that I think that in each of those cases, even when that panel walked in, I probably felt a better feeling just to start with
Right,
because I've been trying to call for the perfect group. And
right.
I'm thinking, okay, here they are. And then that starts the way we're connecting with each other in the courtroom. And it played out really well. So, something to think about.
Yeah. And getting back to the question I asked you earlier, though, what about jury questionnaires? Is that something, has that been a helpful tool or not? What's your thought? What are your thoughts about that?
Well, in my experience, it's judges can be fairly resistant to jury questionnaires, but I've had them used in a few cases, and I found them to be extremely helpful. Um, I think jurors, when you're just questioning them, I think the jurors, in my experience, are most honest in answering the judge's questions, and they're not quite as honest answering our questions as the lawyers because they have more trust in the judge, and I get that. But what was interesting on the cases where a jury questionnaire was used, I think they were the most honest in answering the questionnaire where it's in private. They're just writing it down. And so it could be a very useful tool. It takes some extra time, but I think it saves a lot of time on the back end because you get so much information from the questionnaire even before the judge starts asking any questions. You've got some pretty good information about the potential jurors, and it's very helpful. So I think it's very useful, and I think it can be used even more often.
Well, along those same lines, in terms of when you gather that information and you apply it in your jury selection, or talk about a crucible, right? You have just sometimes milliseconds to make a split second or a split millisecond decision on go or no go, yes or no. I use a little star for yes and a negative sign for no.
Right.
And we all have our tricks and habits and our techniques of then sorting out who might be favorable and who not. And I can remember an instance where on one occasion, I used a jury consultant, and she had insisted on a break that I pick one particular juror for reasons that I didn't already have like a red mark, a negative sign next to him, and that juror turned out to be the jury leader, the foreperson, and that was not a 12-0 verdict, but it was a majority of the 9 or better. I don't remember the exact number, but that particular juror that the consultant counseled me heavily on a break to select turned out to be the key to the win. So what's your experience or feeling or ideas about the use of jury consultants in selecting a jury?
Well, I've used jury consultants some. I mean, earlier on in our career, they didn't even occur in our earlier days, and I think they can be extremely helpful. Um, I don't think they're always necessarily going to be helpful. So it's a case by case thing, and I think it depends upon the lawyer and their comfort level. Like in your case, sounds like it was critical, and it was great you had that consultant. I know I've interviewed a number of plaintiff and defense lawyers, and the defense lawyers tend to use consultants less, but there's still a number of them who will use them regularly. And so I think it's just kind of how comfortable do you feel you are with the jurors in that locality, especially if you're in an area that you try cases a lot, you may feel more comfortable but you can still use a great jury consultant. But I think they're very helpful, especially when you're in an area outside of your normal trial practice and you don't know that area as well. You don't know what the population is like. So I think it's a variation, and sometimes you better have them, and then other areas maybe you feel more comfortable where you don't feel you need them as much. But the good ones are definitely worth their weight in gold.
Yeah, I haven't made great use of them either, but again, on that one occasion, it was a case that what I found is just another set of, not just another set of eyes, but a trained set of eyes that looks for
Right.
telltale signs, body language, details about their background stated or not stated. And sometimes those nuances escape, the one person, the trial attorney sitting there, and just having somebody else kind of watching your, like a wingman, just watching maybe part of the jury or things that you didn't appreciate or see while you're trying to take in the group as a whole and assess each individual in that group. It's a lot. Court diary has always been a um, very fast. It always seems to go extremely fast.
Very fast. Well, to have another set of eyes, another set of ears who are paying attention is extremely helpful. I mean, as a trial lawyer, you've only got your senses. If you have extra senses with either people from your office or a consultant, it certainly helps you. And the jury has all 12 of those sets of eyes and ears. That's why they
Right.
catch everything between them. And so as
Exactly.
a trial lawyer, you're kind of at a disadvantage in that.
Well, I want to move on, Monty, into the time we have with you today to make sure we hit all our hot button items here and all the elements of a trial. You mentioned earlier opening statement. What are your thoughts about what's a good, useful, tried and true approach to opening statements, making your opening statement to the jury?
Well, I think it's important in opening statement to tell a compelling story. And in my experience with trying cases, I think that you need to try to take your legal issue and turn it into some kind of a moral issue where jurors can understand, because jurors and I actually sat on two juries in criminal cases, and my experience from that tells me jurors don't analyze things the way that we do as judges and lawyers, but they want to get the job done right. They're trying to figure out the right answer. So you have to approach it from some sense of value or a moral. And I think you have to find your compelling story, tell it briefly, I like to tell it in a chronological way, and tell it in a way where we have some show and tell with displays and digital graphics, things like that, and just try to help them understand, here's the story and here's why what we're asking for is the right answer.
And in telling your story, how much of the evidence do you try to tell in the opening story? I mean, do you present all your key exhibits or photos? Those might include photos or videos or clips. Of course, it depends on the trial judge. You have to get permission to do anything other than a verbal or oral presentation. But what are your thoughts about that? Like showing a video on your opening statement?
All I will show video clips. Sometimes you might show a video clip of, your client or the opposing defendant if you're on the plaintiff side, and it may be critical testimony. I I don't try to go into every critical document. I think that's too much overload. They're not going to follow everything, and it's going to be too much for them. But I want to give them the basic story in a way that it's understandable and they'll understand as we're putting on evidence during the trial, and they'll already have a total kind of a view of, okay, this is what this is all about. Because as you know, when the evidence comes in, it comes in a disjointed way. You don't get to tell it in your perfect chronology. You don't control the schedule that well. And the witnesses and other things are controlling you. So you just got to give them that framework. But I don't think you want to overload them in the opening statement. And what I also try to do in opening statement, whether I'm a plaintiff or defense, I think it's important in my experience to try to be reasonable, try to be just telling them factually, here's the information, let the story be the thing that creates your reaction, but you're just telling them factually, you're not trying to get emotional and dramatic and all that. I think you can show some of that emotion in the final argument when you've been together with them and they've heard everything. But I think it's better to be a little more reserved in the opening statement, and you're trying to build up that credibility. You're telling them straight facts, you're giving them the truth, you're talking about the bad as well as the good, and you're telling them a story that they understand and that makes sense to them.
Okay, well, now during the presentation of the case, as you call witnesses and introduce exhibits into evidence, what are your thoughts about using trial presentation software to help present that evidence?
Well, I think it's very helpful. I was an early adopter, and I think it's very common now. But it's great for using it. When you got a witness on your stand, you're talking to them about an exhibit, you can have that witness on the screen or that document on the screen. And if you're having them look at a particular sentence or paragraph, you can have that blown up. You have to prepare that ahead of time. You can do that these days with the software on the fly, but I still think it's better to think ahead, prepare ahead, have it all ready to go. And video clips are killer good. So, for example, when I'm doing cross-examination, the way I really love to impeach witnesses and the way I think is the most effective way and impactful way to impeach witnesses is you've got your video clip with the question and answer, and then you show the little transcript below. So you ask them that question, they give their statement that's different from the depo and trial, and you play the clip. That's killer good. That is so powerful. And I think that's the best way, in my view, to try to impeach the witnesses. And that's one of the ways I'm presenting evidence with the cross and cross-examination.
Okay. Evidence code 776 is kind of on my list of things to talk about today. Calling whether or not you call your opposing party as your first witness under 776. What are the benefits, and what do you see to be the risks of doing that?
Well, I've done it both ways in trials. And I think earlier in my cases, in trying plaintiff's cases, I would call the defendant early on. And if the defendant does poorly in their cross, and they often do, that's great. But the detriment is if you have a smart defense lawyer, they're going to just go ahead and do their direct exam in your case in chief right after you've done your cross of their witness. And so they're telling part of their story while you're still starting to tell your story. So over the years, I came to the view that it's not as helpful as what it was touted to be when people were talking about it when I was younger and hadn't tried as many cases. I think there's a place for it, but I think it's much more limited.
And can you give an example? Like, what would be that circumstance where it still might be the better strategy to use? to call your defendant as a witness as part of your case?
Well, I mean, one of the killer things that you can have in certain cases, like in med mal cases, one of the worst things a defense lawyer can ever have is altered records. And if you have a doctor who altered their records, you can score a lot of points and kill them right at the beginning with a 776 of their doctor and get into that.
So it
And
has to be something that strong. And
I think so. Or if the witness is really going to be a bad witness and they're not likable, I think that can still be a good tactic because the jury just hates them from the beginning if it goes that way. But if they're a nice witness and they come across well, that can backfire on you.
got it. Well, speaking of cross-examination of witnesses, when you have the witness, whether it's part of your case in chief, or if you're waiting, we're speaking now, of course, from the plaintiff's perspective, but regardless of which side you're on, you've got an important witness adverse to your point of view. What are your thoughts? And you make a few comments about the difference between closed cross-examination or open cross-examination.
Yeah.
I think we're all schooled to never ask the question you don't know the answer to. That's sort of the cross-examination 101. But I think it's probably a little more subtle and more complicated than that. What are your thoughts?
Yeah, I think it's definitely more nuanced and more complicated. Most of my cross, I will still do the closed cross, which is traditional thing we're taught to control the witness, don't give them much leeway, try to get short answers. But over the years, I got as a young lawyer, and this was probably in the mid 1980s, we had this terrific trial lawyer. He's passed recently, did a lot of criminal defense, but he did other plaintiffs work. His name was Milt Silverman. And he gave an example in an in of court program I got to watch where a very talented trial lawyer was one of the best in town too, a guy named Jerry McMahon, did a classic closed cross of this witness. Brilliant. Milt gets up and he does what I would call an open cross. Total freewheeling, totally different. He's not trying to control the witness. He's telling his story. He's doing what he wants to do. He was so effective with that. He was really a master of it. And another guy who recently passed away, who was a master of it, was Jerry Spence. So he would do, and Spence would describe his open cross as, I don't care what their answer is.
Exactly.
I'm telling the story of my case, and they're not going to agree with me. I don't care. And he was brilliant at it. So I've actually used both, and I can say that the open cross can be very effective. I think a lot of lawyers are afraid to try it. I think it's worth trying when you have more experience, and it can be very effective. It's something with trial work, you got to be comfortable with being yourself. And so some people are just going to be closed cross people. But I've used both approaches. And in fact, I used an open cross approach a number of years ago in a business case. And the CPA I was crossing was somebody I had as my expert many, many times for many years. He would have talked to me for 6 months afterwards. I was saying, hey, I'm just doing my job. So I think you have to use both the open and the closed, more so the closed. And then I want to go to the next thing, and that is, yeah, you say we're told never ask a question you don't know the answer to. I'm a contrarian on that. I would say 95 to 98 or 99% of the time, I would agree. Don't ask a question. But what I've learned in trials, and I've done this in trial, and it's been very successful, if you know your case well, there are very rarely, but they occur. There will be a time when you're preparing your cross, and it's an important point, and you realize I don't know what they're going to say because it wasn't covered in depo. But if you know the documents in the case well enough, sometimes there's no good answer for them. You should ask the question then, and it's killer good when you do.
Yeah, I I agree with that 100%. It's when you try to formulate questions that you don't really care what the answer is because there is no good answer to it. That's
Right.
the trick. Yeah. Well, not a trick, but that's the method that you can use to. And also, I think in that situation, if you don't ask the question and the jury wants to know the answer, you've really let them down as well.
Right.
Sometimes you have to venture where you might not feel 100% certain of what's going to happen, but you need to know, and because the jury wants to know.
But I think it's also, you have to be well prepared for trial, and you have to put in a lot of time and a lot of effort. But when you are well prepared, you'll be able to make that analysis at the appropriate time. And you'll be able to see that, oh, this is a 1 in 100 opportunity to ask a question. And I think you should do it then.
All right, now we've gotten through all the core elements of most trials, and you're done and gotten your 12-0 verdict. Congratulations, Monty, you did it again. And what might be of use to some of our viewers is thinking about and talking a little bit about what do you do after a trial, which is kind of like what do you do after the war is over, right? War is it's a tough battle, and win or lose, you come out of it. Do you have a method or a routine you use for regrouping and pulling yourself back together after that exhausting experience?
Yeah, I call it, after every trial, I call it the post-adrenaline crash. Because you've been on adrenaline for the whole time of the prep, the whole time of the trial. You've been going at 100 miles an hour. You've been thinking. You're at a level that you just are not commonly at, and you're engrossed in this. It's a full contact engagement.
Right.
And then when you're done, when I'm done, I'm exhausted. My body just goes, whoa. So I sleep. I don't worry about trying to, get up after so many hours or not. You got to get lots of sleep. And the longer the trial is, the more days of a lot of sleep you got to get. Just try to not do a whole lot of work in the office. Sometimes you're not going to get that luxury with other stuff coming up. But if you can, I just think you got to take some time, rest, get some nourishment, get lots of sleep. Don't be doing much of anything, and the body will come back. But I think if you try to, press on and you have a full day of stuff the next day or next couple of days, you're not going to be very effective.
Yeah, and not doing your other clients any favors by coming back in that depleted state, recharge and regroup. And,
Right.
Kind of going back to the back in time a little bit, when you think back over the start of your career, did you ever have any mentors? I mean, you mentioned some, top-notch examples of people, and the same advice is often given. Get out and look at a trial, find out who's trying something in court that's worth watching, and go down and just watch. And modernly, I mean, you could even do that remotely by just getting on the court's remote, making a remote, not a remote appearance, but participate, observe.
Right.
One way or the other, take it in. But how do you? A mentor is a little bit different. I want to talk a little bit about, ask you to talk a little bit about mentors and somebody that you can reach out to personally and get guidance and inspiration from. Did you have any mentors in your formative years?
Yeah, I was very fortunate. When I was working at the McGinnis Fitzgerald firm, the first person I worked with for a long period of time was a great lawyer, later became a judge, named Jim Milliken. And Jim was phenomenal. That firm did 100% defense work, and he was the only partner at the time. He did half plaintiff, half defense. So as a young lawyer working for Jim, I got the luxury and the joy of getting to represent people on both sides. And I liked both sides. I really enjoyed it. And some people just get one or the other. Jim was a great mentor, really taught me a lot. I worked also with Gary Bailey and did mid-mal cases with him. He was a hell of a trial lawyer, and I learned a lot from him. When I started practicing in San Diego, and I took this San Diego of Court course, I got to see as demonstrators Jerry McMahon give a demonstration, and I got to see Dan Broderick, who was an outstanding plaintiff's lawyer. Jerry was more of a defense business lawyer. And both those people, as a first year lawyer, I said, those people are excellent. And if I can learn things from them, I think I can become the best I can be. And so I did observe them, watch them. Actually, when I worked with Gary Bailey, I had a number of cases where Dan Broderick was on the other side. He was a plaintiff's lawyer. And so I learned a lot being in deposition, being in hearings, and interacting with them. And I also learned a lot from Jerry McMahon over the years. And actually, later in my career, I decided I was going to go and do more business litigation. And I had been tried enough cases, I didn't really need to look for mentoring then. But the one lawyer who was still practicing in town, who I said, I think I could learn a lot of good stuff from, was Jerry McMahon. And that made me reach out to the firm he was with. And I was very fortunate to work with him and learn some great things, even though I'd been practicing for a number of years. So I've been fortunate. And I think you and I were fortunate when we were younger. I think in the 80s, law firms took more time and did more mentoring and training. And then sadly, I think that's been lost over the last 30 plus years. And younger lawyers aren't getting that kind of mentoring, and they need it. And they will get better faster if they have some, but everybody's so busy.
Yeah, and I was going to ask you that question. In present day, how does a newer lawyer go about finding a mentor? What are your thoughts about that?
Well, I'll tell you what, I'll just give that, and let me make that also my answer to the question of what's the advice for young lawyers, because that's
Right.
part, and that's what I always end with. So my advice to young lawyers would be, if you want to become a trial lawyer, number one, if you're in San Diego, take that San Diego Inn of Court class teaching you how to try a case. And they do that for about 6 or 8 weeks. And you get demonstrators who are some of the best in town showing you how to do voir dire, opening statement, all that stuff. Then you get to practice in the courtroom on, fact patterns, doing it in front of lawyers who are experienced lawyers giving you feedback. And you even get to work with potential jurors in the voir dire part. That same San Diego Inn of Court does an evidentiary program where you learn how to make objections and how to raise objections. That's a must. Other communities have similar programs. So if you're not in San Diego, I advise that you do that. We have the American Inns of Court. They're all over the country. Those are great places for young people to not only learn how to be a trial lawyer, but also how to meet people who are more experienced. And then you may get a mentor from that, because you will work with judges or masters, attorneys with a lot of experience, or attorneys with maybe more years of experience. And that's a great way to meet people and learn who may be a mentor. I think you just observe, as you're in your community, who are people who have a great reputation, who are people who are really effective in what they do, and you can try to get to know them, or you can try to get to watch them trying cases or doing things. That's another great way to do it. ABOTA has a national trial college every year. You're going to get trained by the best of the best. That's a great thing to go to. The NIDA has trial things where you train in trial. That's another good training. Also, you have with the ABA, you have the TIPS, which is the Tort Insurance Practice section. They've got a trial college. So that's another opportunity where you can go and get some training from people who are really good in their field.
Right.
And the other thing I would, in addition to those things, I would say go to seminars with trial lawyers, or you can see it online these days. You don't even have to go there in person. Learn from people who are doing it, and they're doing it, and they can give you the tips of what's going on, what's working today. And I think it's good for you, if you're going to be a good trial lawyer, to try to be constantly learning your evidence, constantly learning your civil procedure, constantly reading up on that and getting that so you know it better and better and better. And then by that kind of an effort over a number of years, you can keep improving your skills. And if you're constantly trying to improve your skills, I think over time, you're going to become one of the better people. And if you're a trial lawyer, you're going to become one of the better trial lawyers. If you're in the courtroom, if you're constantly learning, constantly growing. And I think that's one fun thing about the trial practice is you are constantly learning, constantly growing. So that would be the advice I would have to give. And the final advice to young people is you got to be yourself, and you got to be true to who you are. I've tried some Jerry Spence things in the past that didn't work because it's not my personality. But I realized that I didn't use those anymore. But I
Yeah,
tried.
I don't picture you in buckskin suits.
Yeah, yeah. I'm not a buckskin suit guy, but that's okay. And the other thing I think you have to do is just like with any competition, you can't be afraid to lose. You got to be willing to go. And if you're a real trial lawyer, you're going to lose some cases. There's no trial lawyer, in my experience, who's never lost a case, even though claims have been made. But I think you have to be willing to go, do your best, always be prepared, and be willing to accept the fact that you're not going to win all the time is a terrible disappointment. It may be hell of an expense, but you got to go be willing to fight the fight. That's how you're a trial lawyer.
Well, fabulous, Monty. Thank you so much. It's been a pleasure to share your experiences and revisit some of our mutual experiences and to share them with our fellow trial advocates. If anyone watching or listening to this podcast wants to learn more about Monty's past and current work in the legal field, he's got a website, as we all do, California Case Summaries.mykajab.com, or just Google California Case Summaries and put Monty's name, McIntyre, in there, and you'll see all his current activities as I described them before. You can also email Monty directly. He's a very accessible guy, Monty, M-O-N-T-Y, at montymcintyre.com, or call him. And if you don't mind me, I'll give the number. Monty, it's 619-990-4312. If you have any questions or comments for me, my email address is anton@gershlerlaw.com, and my cell is my only phone in the world at this point is 619, because who needs a landline? There's no such thing, right? It's 619-507-9411, 9411. And as Monty always likes to say at the close of his podcasts, Monty?
Well, Anton, thanks for being a great guest host and doing a wonderful interview. I had a lot of fun doing it with you. It's always so much fun to sit and talk to the lawyers, and you did a great job. I really appreciate it as a fellow ABOTA member. Thanks for doing this. And now that we're done with this session, do well and be well. Take care, everybody.